Good evening, everybody. If everyone could take their seats. On tonight's agenda, the Public Services Committee meeting scheduled at 6:15 has been postponed. That will be rescheduled to a later date. Right now, we're going to do the Ad Hoc Committee on Medical Marijuana. And first, the mayor would like to say a few words about it. Then City Solicitor Mike Smazinski is going to talk a little bit about the process itself, and also there was a question about a special permit application I believe he will address, and then we'll open it up to the councilors to talk about going forward, the process and how it'll be going forward. So, Mayor?
Great. Thank you, Mr. Chairman, and I'll be very brief. Certainly, I think all of you know my position on medical marijuana. It's certainly been an issue that we've been discussing and debating for several months now, several meetings. I've took a very hard position that I did not support in any way marijuana coming to our community, but after learning about the value of medical marijuana and the treatment value for people that have relief from medical marijuana, I certainly thought that it made sense to have a facility here in the city of Peabody. I was concerned about where the location would be within the city, and I think that we've determined a good area on Route 1 that's accessible for people in order to go ahead and have the medical marijuana prescription that they need. The reason I'm here is I felt that I wanted to explain the reasoning behind allowing the City Council the opportunity to handle the non-opposition letters. And it just came down very simply. I've been reached out to by a large number of people that are interested in the city of Peabody to open up a medical marijuana facility. And I just felt that it was best to have it out in the open, have a very transparent process, open it up for full debate, rather than meeting behind closed doors and discussing this. And I thought the City Council, you have been a part of this. I think a lot of us share the same opinions, and I just felt that that was the best course of action again. And really, it's all about transparency and making sure that we have a full debate on these issues. I think we have some very qualified people that are interested in the city, and I just felt that this all should be played out and heard and have full debate by the City Council. Certainly, and I would be a part of it. I know our city solicitor has been working extremely hard gathering information on these topics to give the best guidance he can to help with the decisions that we have to make. And certainly I'll be giving my opinions if asked as we move forward. But I just thought that because of this issue, and so many of you have been on top of it and doing your own research and studying it, I just thought that was the appropriate way to go. And I just wanted to give that as an explanation. But certainly I'm going to be a part of it and willing to give my opinion at any time. But I did want to turn it over to the City Solicitor Mike Smazinski. I know he has a great deal of information he wants to provide to help with the hearing and to help us navigate through some of the issues that we'll be presented with. Thank you, Mr. Chairman.
Thank you. Councilor Smazinski, please.
Mr. Chairman, members of the committee, thank you for having me. There are two things of great importance. First of all, I received a concession from the chair to be able to sit. I'm very much accustomed to standing, but today I'm going to sit because of the second point. And the second point is I'm going to have to bore you. I'm going to have to read a lot of information to you to make sure it's put in your hands. And obviously I can come back and review it and sharpen the points that are made. But please bear with me, okay? The subject of this hearing is titled Criteria for Letter of Non-Opposition. To address this topic, you need to know that the statutory framework within which a description of this subject can be formulated. Medical marijuana and the regulation and the establishment of medical marijuana dispensaries are controlled by a combination of state law, Department of Public Health regulations, that's on the state level, and our local zoning ordinance. The applicable sections of the Mass General Laws and Code of Massachusetts regulations grant flexibility to municipalities like Peabody in the order, timing, level of participation, and decision-making associated with the potential licensing and registration and permitting of a dispensary. Something of great importance is that the Department of Public Health specifically notes that municipal permitting may take place at any time during the registration process. Again, permitting is on the state level, registration is on the municipal level, and permitting is on the municipal level. Based on those parameters, Peabody, us, adopted a zoning ordinance at section 6.13, 613, medical marijuana facilities. Coincidentally, the council just solicited an opinion from my office evaluating the validity of a special permit application filed without a site-specific provisional certificate of registration issued by the DPH. Consistent with that opinion and the legal authority supporting it, the process in Peabody, and this is important, defers municipal permitting to the later phases of the state registration process. That is a very important factor, and I know I have legalese, that's permeated through what I'm reading, but it's very important that that's what our ordinance did, and that was within the bandwidth of what the state gave us discretionary-wise in formulating our relationship with potential dispensaries, the state law, and our own local restrictions. A prospective dispensary operator needs to obtain a provisional certificate of registration for property in our permitted district before filing for a special permit. That was the opinion that I just gave, and I think you all may have received it. To obtain this certificate, the prospective operator must file an application of intent with DPH proving nonprofit incorporation, proof of initial capital, which is very substantial, and character and competency representations. Then the prospective operator needs to satisfy a management and operations profile, which includes background checks. It includes other things, but it's quite a burdensome process. After those two phases, the prospective operator must submit a siting profile, which must include, and this is the drum roll, the letter of municipal support or non-opposition. It is very important to know that the applicant must show it has acquired municipal permitting or, and this is again very important, in those municipalities like Peabody who require local permitting later, a demonstration as how the facility will comply prospectively with all local zoning. If this process regarding the siting results in a favorable assessment on the state level, the prospective dispensary gets the provisional certificate. They can then pursue a special permit with the council with the burden of satisfying the criteria, which is also pretty expansive, in our own zoning ordinance. After the final building and occupancy permits issued, then a final certificate of registration based on further state inspections must issue. I outline this process to distinguish between two approaches to the issuance of letters of support of non-opposition. My city solicitors and town council group, the Mass Municipal Lawyers Association, has actively commented upon this issue. The first thing to understand is that there is no state law or regulation with contact that can help us understand the answer to your question about criteria for such letters. Notwithstanding, the prevalent view is that communities that do not have restrictive zoning or do not defer local permitting until after the information submission and evaluation process on the state level should use this letter issuance task as the community's ultimate position relative to a prospective operator. In contrast, the view for communities like Peabody, which has restrictive zoning and defers local permitting to the latter part of the registration process, should use the letter issuance task as a gatekeeper function and focus upon obvious disqualifiers. And this is where I have to interject. It's two different approaches altogether. One is very, very conservative, almost like the final decision, and the latter, which is within the framework that we have, would be more liberal, passing passing people through unless there's an obvious disqualifier to go through the state process and then come back for our process. I cannot predict the nature of these disqualifiers, as all cases are fact sensitive. The thinking is that this committee should not be duplicating the efforts and assessments that will go into the state and prospective local approvals required after a letter is issued. In other words, you shouldn't be doing the same things twice. And that's in support of a liberal approach at this stage of the game to prospective dispensary operators. The legal community also recognizes that there is no guidance on a cap on the number of letters that can issue or the method of declining to issue a letter. This also applies to the potential question of issuing or not issuing a letter between competitors. I wish I had better news for you, but there's just not any precedent to extract great guidance in your ultimate task. And as an aside, I can tell you that we lived through a very analogous situation. We ended up having competing special permit applications for billboards. Remember Sonic and Alfie. Now, the council ultimately made a decision, one over another. 4 lawsuits, 4 years later, and the appeals court and Superior Court ultimately upheld all the decision-making made by the council. I cite this because it is very analogous, and it also has the prospect of, lengthy legal entanglement. But in the end, and this is what I can say by way of encouragement to the council, if you are compelled and have the intestinal fortitude to make a decision and put the reasons in the record, you can prevail in the end if you're going to end up making choices. But again, everything's fact sensitive, and to a certain extent, you're going to have to take it as it comes. I also want to cite what just occurred in Lynn. 2 dispensaries were approved. One was rejected, and that is now the subject of a lawsuit that was just filed a couple weeks ago. So I'm going to be following that with great interest. It's Crowley versus the City Council of Lynn. Returning to the presentation, on one of the best shared commentaries in my group, and obviously I didn't write this, one of the city solicitors summarized it for our group by saying, Department of Public Health did not provide any guidelines or impose any limitations on the executive body's discretion in deciding whether or not to issue the letter of support or non-opposition for a medical marijuana facility before developing a set of explicit criteria. And this kind of goes to what you're looking to examine tonight. Consider the risk involved. You may create a basis which would not otherwise exist for an unsuccessful applicant to bring a certiorari appeal and assert that a negative decision was arbitrary and capricious. You've heard those terms with all the special permit lawsuits. Particularly if there are competing proposals and the unsuccessful applicant argues that its proposal satisfied the criteria while the approved one did not. In practice, the request for the letter is an opportunity to consider factors that might not be covered by a zoning bylaw, special permit requirement, including fiscal impacts on the town, the qualifications of the applicant's staff, hours of operation, and the mitigation to be incorporated into a host community agreement. And this is what else he said. If there isn't a zoning special permit requirement, the letter approval process is a chance to undertake a zoning-like review. However, any resulting conditions should be incorporated into the host community agreement because the DPH rules do not provide for the letter itself to impose conditions on the approval. Many of the issues mentioned in the quote that I just gave you are covered in our section 6.13. However, host agreements are not enumerated and are certainly not most certainly the object of discussion. I do note that the last state law amendment this past July, Chapter 55 of the Acts and Resolves of 217, specifically established limits on host agreements. It states a marijuana establishment or a medical marijuana treatment center seeking to operate or continue to operate in a municipality which permits such operation shall execute an agreement with the host community setting forth the conditions to have a marijuana establishment or medical marijuana treatment center located within the host community, which shall include but not be limited to all stipulations of responsibilities between the host community and the marijuana establishment or a medical marijuana treatment center. And an agreement between a marijuana establishment or a medical marijuana treatment center and a host community may include a community impact fee for the host community, provided, and this isn't the important part, that the community impact fee shall be reasonably related to the cost imposed upon the municipality by the operation of the marijuana establishment or medical marijuana treatment center, and shall not amount to more than 3% of the gross sales of the marijuana establishment or medical marijuana treatment center, or to be effective for longer than 5 years. Any cost to a city or town imposed by the operation of a marijuana establishment or a medical marijuana treatment center shall be documented and considered a public record under state law. I just want to let you know, some of these host agreements are unbelievable. I can tell you that there's one that's being vetted in North Reading that's just unbelievable, and it would be a good guide in terms of creating a checklist of issues that you may want to consider and cover as the process goes forward. With all these observations in mind, the question comes to process. Since the responsibility for issuing such letters has been directed to the council, the advisable course is to undertake the decision-making consistent with the open meeting format so as to ensure notice and opportunity to be heard in a transparent, democratic fashion. In consult with the council president, I understand that he may ask the committee to undertake public presentations of each entity seeking such a letter on October 26, 2017. Again, that was just discussion, and it's non-binding, but at least it's a place to start the discussion. If that's going to be so, or whatever the date may be, it's recommended that notices to each entity be served describing the place, time, and date of the meeting, an invitation to make a presentation in support of its request for a letter. You may consider parliamentary rules in terms of the time allotted for petitioner's case in chief, question and answer time, rebuttal time, and perhaps time to submit additional documentary evidence post-hearing to be considered in the decision-making. There may be a, I'm sorry, everybody. Oh, all I can say, it's the wife. Don't forget the bread on the way home. Where I left off is there may be a sentiment also to indicate, especially in the notice, that the council may undertake its own debate and vote at a hearing subsequent to the date and times of the presentations. So that's essentially the format, and to sum it up, if you really undertake the calculus of taking all precedent and the legal commentary, given our structure, especially with a very extensive special permit process, and that being compelled to take place later in the registration process on the state end, it's a very liberal approach to the issuance and adjudication of requests for letters in this community at this time.
Thank you. Council Gould?
Thank you, Mr. President. Thank you, Attorney Smozinski. Could you reread that, please? Only kidding, Mike.
I was going to have Tim do it because he's so adept at it.
Mike, my head is spinning. Can you, in lay terms, give us 30 seconds to a minute of what we are charged with as a subcommittee and then as a full council, what the steps are?
Yeah, I mean,
Please.
to boil it down, number one, give each applicant for a letter opportunity to be heard. Give them a council or committee hearing and let them make a presentation, ask your questions. And then you're going to have to undertake a vote by majority to make a determination as to whether you're going to issue a letter. And Counselor, I know you want, you know, a bright line test. What should we be doing? And I'm advising you with all this legalese is that because of the way we've set up our zoning ordinance relative to medical marijuana facilities, dispensary approval, the issuance of a letter most likely should be issued unless there's some patent, obvious disqualifying condition. It's not like the communities that don't have the type of special permit ordinance and the timing for its adjudication that would have to use this process almost like a special permit, you know, critical view.
Do you have a template that we should be looking at for, in order to help us make the decision on applicants or on this letter of non-opposition? Is there are there going to be guidelines for us?
That's the punchline, Tom. There aren't any guidelines. There's nothing in state law, in terms of the general laws. There's nothing in the DPH regulations. There's a lot of discussion, commentary-wise, among the legal scholars, you know, within my group. And the only distinction is the conservative versus liberal approach to these letters based on what you have for zoning and when you compel an applicant to get municipal zoning. Again, and I don't mind saying it, I hope I don't bore those by being repetitive, but since we do have a very detailed zoning ordinance pertaining to dispensaries, and we require them to go through a significant portion of the state registration process before they come to us, the issuance of the letters should be liberally viewed.
They, Mr. President, there are how many applicants for how many licenses?
So to recap, when we zone the area, we zone 4 parcels of land. At this point in time, I've been in touch with 3 of the 4 entities that expressed an interest in going forward. For matter of public record, I believe there are 2 that have submitted requesting a letter of non-opposition. I believe there's a 3rd one that most likely will be coming, but as far as we sit here tonight, I'm only aware of 2.
Back to Mr. Smozinski. Mike, so have a hearing, make a determination on whether we submit to those applicants a letter of non-opposition, and then it comes back to us to do a full special permit hearing?
Yes. You would have a hearing, and whether you decided on the day of the hearing or at a subsequent hearing, you make your determinations on issuing the letters. If you do issue letters, those prospective dispensary operators then will be going forward to the state, and if they get through the next phase, then they'll return to us for full special permit hearings and the negotiation of a host agreement.
Does the letter of non-opposition come from President of the Council, yourself, or the mayor, or all 3?
There's actually a form, and when a community elects option B and it's the council, there's literally a pre-printed form that I'm going to actually give to you, you know, as the operative document to transmit to the prospective operator and state DPH.
Thank you. I feel a lot better about the process than I did 10 minutes ago. Thank you.
Council Turco?
Thank you, Mr. Chairman. So, through you to Attorney Smozinski, the host agreement, so if we give out 4 letters of non-opposition, then we're presented with 4 special permits and 4 host agreements. At the special permit hearing, we will have that information in hand as to what the host agreements say in them.
I'm going to break that down into 2 different issues. We don't know and can't really predict what the timing is going to be in terms of who ends up returning first or last or as a group with special permit applications. Again, by analogy, it can end up very much like the way we saw the billboard special permit applications come in. But if you take a look at the DPH process, and there's extensive information online, you know, each operator is going to be at a different phase, and each of those phases takes a significant amount of time, you know, to get through before they're going to return. So just because you may issue letters in bulk at one time doesn't necessarily mean that they're all going to return at the same time. So again, as to that issue, you know, that's left up in the air. And again, it's akin to dealing with the billboards. And, you know, of course, you saw what we went through an experience when abutters competed for billboard approvals, and you could only have one of the 2. Now, as to the host agreement, you know, you're going to be able to, you know, talk about this through the special permit process. You can talk about this, you know, and gather information on what these particular applicants or requesters for letters of opposition, I mean, non-opposition or support, you know, want to put on the table. I did add into my presentation, you know, the significant restrictions that now exist in terms of the cap on the percentage and the time, and I'm sure you're going to hear that from all of the potential prospective operators. But you can talk about the host agreement at the hearing that may come up relative to issuing the letters.
And Council, just to follow up on that, if I heard you correctly, if we gave out multiple letters and they went to the state, and someone came back and they were vetted at the state level first, and they came back and they put that special permit in, how could we deny that special permit if they were the first one back to the city of Peabody? That concerns me. If it sounds like if we do that, then we as a municipality, we lose control because we give multiple letters. Whoever goes to the state and gets back to Peabody first and has a special permit, we as a body have to vote on that in a period of time. We don't have to, you know, and we have to give them, and you said it yourself, the expectation is if they come back from the state and they were vetted and they have the certificate, then we would have that special permit. So now, aren't we beholden to how quickly the state gets done with their business at their level?
Yes.
So I'm gonna refrain. I'm gonna let you to continue. I do have some, as you all know, I've spent some time on this. I'm gonna give you some guidance from my perspective, but I thought that was important to follow that point up because most of you have been there through the billboards. You remember what happened with the billboards. I'd like to see this city have control and not the state have control. Councilor Gravel, excuse me.
So, understanding that what you're saying is we're going to follow a fairly liberal rule, I hope that I guess I want to make sure I'm interpreting that correctly. We have a hearing. It doesn't mean like everybody gets a trophy, and no matter what they say at the hearing, we issue a letter. Am I interpreting that correctly?
Just so you know, for them to even, well, let me take a step back. Does everyone get a trophy? No. Are you still empowered to exercise all of your discretion, especially akin to what the criteria for issuing or denying special permits are in this process? Yeah, that's a list of issues that you can use. Can you deny? Yes, you can deny. I'm talking about the letters. Can you approve? Yes, you can approve. But again, given the fact that we make them get the state approval before coming back on a special permit, and again, this is not case law, it's not regulatory, it's not state law from any source. You know, the real thinking is only serious, disqualifying, obvious deficiencies with an applicant or its proposed operation would most likely be sustained if there was a lawsuit. That's what I'm saying, Dave. But I can't tell you, you know, what specific facts constitute a thumbs up or a thumbs down. We all know one thing, that, you know, we have this zone, and you know, in one sense, the blessing is that there's a great benefit to have a couple 100,000 cars go by your front door. But then again, there is a, you know, a concern, and I'm sure you have it, with traffic safety, people coming and going, what's going to be the number of trips and how that's going to be managed. I would think that would be one of the greater issues that's going to be vetted. And, you know, picking a public safety plan that's optimum for the city would be a great factor, you know, to hang your hats on in determining which applicant has a better proposal for the overall community versus a less advantageous proposal.
So you're touching on an area that I had spoken to Joel about as it pertains to evaluating the presentations, because to me, just having people come in and present without any evaluation criteria would leave you the most exposed, in that you're not qualifying anything. You're not saying, well, what is it that you're actually looking for? And I understood a part of it saying you can't be looking for exactly what the state is looking for, but from a community's perspective, you could be looking for, and correct me if I'm wrong, you could be looking for what the community is concerned with. So for instance, could certain, and I know you can't give me the list of, I'm not asking you to, but would you advise the council before we have a presentation to build somewhat of a rubric of what we want to see in what we call a qualified presentation, so that it's fair for everybody who comes, that we talk about things, and I'll just pull them off the top of my head. Years of experience in dealing with these types of issues, and how they, what their what the background qualifications of the owners are going to be, and what their plan for our operation is in terms of how they plan to deliver and ensure that, the stuff isn't getting in the wrong hands, etc. I mean, just coming up with some real qualifying that you could rate on a scale and say, this one ends up being a 10 and that one ends up being a 2. And they may all get a letter, but at least when it comes back in terms of determining who gets the permit, we have at least said, in our eyes, this one is the higher quality individual based on the presentation that they brought forward.
If you take a look at, my colleague who authored it, he actually was arguing against creating that type of criteria at this stage of the game. But in the same breath, and I know, you have an appreciation for all the different criteria and the special permit process under the zoning ordinance, under under section 9 of 40A, because there's a list of those things. All of the different criteria that we have in our zoning ordinance already for medical marijuana dispensaries, and what's in the state regulations. All of those topics are fair game. Are you going to make a determination of special permit significance at this stage of the game? That's what my colleagues are arguing against, because you have a second shot at them.
Just one more thing, and I hope you can assure me this, because I have, well, one is the concern that, well, I guess that's been taken care of by the state in terms of the concern that somebody could go from medical to recreational in the same step. If a community disallows recreational, then that's out. But
may I make one point, if you don't mind? Host agreements can include a commitment and covenant not to ever go recreational pot, even in a community that allows it, you know, or doesn't take action regarding either the legislative prohibition or a referendum against recreational. I just want to make that point.
no, and I appreciate that, because that was a concern of mine. But the second concern I had, and I'm hoping that I hear the answer I want to hear, but sometimes you don't get to hear the answers you want to hear. I've never been a believer that liquor licenses are the subject of arbitrage, and that licenses that were issued through communities by the state being sold, bought and sold in the secondary market, has resulted in sometimes liquor licenses selling for hundreds of thousands of dollars once they were obtained by the first legitimate person, being transferred to others, and it became like property. I'm hoping that this type of license doesn't become like property, that one person legitimately gets it by going through a process and then is able to sell it to somebody else because they had it. Is that the case?
Yeah, it's a source of somewhat pride, because I had to try the case a number of months ago with the local establishment at the ABCC, and they were crying foul that the city diluted their ability to cash out on their license on a private transfer because of the assignment of additional locations and licenses. We prevailed, and we do have that restriction on transferability in our ordinance.
Council Manning Martin.
Thank you, Mr. Chairman. Through you to Attorney Smozinski, you mentioned the billboards, and the case, if my memory serves me correctly, that you're referencing was due to restrictions that the state had, like a buffer zone. You had to have X amount of feet between a static and or digitals. So the situation we were in was there were restrictions upon us because they were submitted to us with those restrictions. So we couldn't say yes to both of them. We could only say yes to one of them. And for whatever reasons we did. But so it seems that this is apples and oranges to me, unless I'm unfamiliar with, which I'm unfamiliar with the whole thing, but unless you can point out a flaw in my thinking, is it seems to be different in this regard, because unless we wrote a buffer zone in our zoning to limit the number of medicinal marijuana dispensaries we can put on that in that zoning area, or if the state has regulations such as they do with the billboards that you can't have medicinal marijuana dispensaries within a certain area, if there's a buffer zone that I'm not aware of. I mean, is there? Or it just seems to be apples and oranges, because if we have a medicinal marijuana zone and we have 2 applicants or 3 applicants, if you can fit 3 applicants on there and we don't have any restriction in our zoning, or the state doesn't put that restriction upon us, why are we going at this like we can only select one? Why are we saying at this point, at this juncture, why are we saying we have to pick one when we don't even know how many there are or how many would fit on our medicinal marijuana zone? So are there restrictions or regulations in either our zoning or with the state that limits us to the number that we can put in our zoning of medicinal marijuana? Thank you.
Okay, I'll try to take each of your comments in order. First of all, there are apples and apples. If you remember what happened with Sonic and Alfie, literally the applications for each of the special permits for digital billboards were at the counter to be stamped in at the same time. So that we were confronted with, oh my God, 2 essentially simultaneous applications. No one person really beat the other. As a matter of fact, I think they were stamped in within a matter of seconds, I think. But in any event, we didn't necessarily take the position that, oh, we have to issue one because of the restriction, because we did have the power to issue special permits to both and let them fight it out at the state. We took the additional position that the upland a billboard would be least intrusive and more consistent with the objectives of zoning, and ultimately that's the rationale that prevailed. So there is an apple-to-apple correspondence to multiple simultaneous applicants in our zone. Now, in terms of our zoning ordinance, we don't have a restriction as to how many, and the state has abided by an assignment of a fixed number per county, so that it's very conceivable that we could issue special permits, but the state, or multiple letters, and the state may take, and I don't know for sure, a hard stance on how many would be able to go forward. The process of having the state doing a lot of this work is, well, some may consider it genius, or a pass off, but it allows the state to use its resource to help us pick a more favorable candidate. And, we get to sit and then decide how to handle the result that comes out at the end of the pipe. So I think I answered your question.
You did, but ultimately there's no restriction on, we could have 2 or 3 in that medicinal marijuana zone if they presented themselves to us and there was no reason to reject them, then we could.
Theoretically, it's a possibility.
Thank you.
Any other councils at this time? So, following up on Council Manning's point, I'm going to appeal to the council for 1. The discussion from day 1 from the corner office has always been 1. This is my ward. We talked about it. There's nothing in the ordinance, I agree, but the expectation has always been 1. If we're going to add a second or third, I feel we should look at other areas across the city. Why do both have to be side by side on Route 1? That's my personal commentary. I'm going to ask the council to continue with that process of looking at 1 for the reasons I just outlined. If you want to go into 2 or 3, there are certainly other areas of the city that are appropriate that are not near houses of worship, schools, things of that nature that we've tried to be protective of. So that's my commentary on that. Talking about some of the things that Mike brought up, I want to give another example, and I come from a little bit of a different perspective than him. His perspective, and I think this is critical, is to be liberal with the letters. Well, we take a step back. imagine if we, as a board, zoned a mile of Route 1, north and south. We could have 200 parcels of land. Were we going to give out 200 letters of non-opposition? I don't think we would. I think the whole process has been to try and control it at a local level and to try and have a say in who's going to operate in our city. So let me ask you this, Mike. Are you aware of any litigation of someone suing a municipality, a town, or city for not getting a letter of non-opposition?
No.
But you all know that there are numerous lawsuits, us included, for not giving special permits out. They come down the pike left and right. We don't give someone a special permit, they can look at that and they can decide for many different reasons why they feel it was biased, they didn't get that special permit. So what I want to go back to is I'm going to use the city solicitor's terminology. I'm trying to, and I believe you all are trying to, protect us from lengthy legal entanglement. We don't want to be in court. How do we protect ourselves? I believe we protect ourselves by giving one letter out, let them go to the state, get vetted at the state, and then come back here. We talked a little bit about the process, and we'll make the assumption there'll be multiple applicants looking for the letter of non-opposition. As has been discussed, I floated out the date of October 26th came out, and that's a moving target, just so everyone knows. We can change that if we have to be comfortable with that. But I think definitely by the end of the year, we want to invite the parties to come in and to make their presentation. I believe, as they did in Lynn, and I watched it, there were 4 parties. They came in, they gave a presentation. We set a time limit, say 20, 25 minutes. Each one can give their presentation, and then you as a council will have 10 minutes to then ask them about their presentation. I think it's important to limit it. In Lynn, they gave 12 minutes. I think one went to 13, and to be quite frank with you, it was not, I don't think it was, I think a little extra time was needed for all parties involved that evening. So now we talk about a host agreement. My assumption is when we get those presentations that evening, that these entities are going to put their best foot forward. I expect them to talk about enhancements to the above and beyond the 3%, whether they want to contribute to Peabody Health Collaborative, whether they want to contribute to whatever they feel that the city might benefit from. I don't think it's, now I understand that that is not going to be the ironclad host agreement, but I would expect them to come that night and put a proposal on what they want to do and put their best foot forward. Let's talk a little bit about the criteria for a letter of non-opposition. That's the elephant in the room. There is no guideline. That's why we're having this meeting tonight. I understood that. I was concerned about that. I didn't want us to go into the meeting when we have it that we have no idea. So I'm going to give you a little bit of an idea of some of a broad general outline of what I've come up with, and then maybe what we need to do is, after I talk about it, we can add to it, subtract from it, but I think there might be a need for maybe one more subcommittee meeting to then come up with that report card, because I agree with Council Gravel. I do believe that you take maybe 5 criteria, you put it down on a scale of 0 to 10, you grade them out, and then you vote on them. I think we have to try and do some due diligence, and we want to have some control. So maybe, let me give you some examples of areas that you might want to look at an entity that comes before us that wants to do a medical marijuana facility. Maybe the applicant's relationship to Peabody. Are people who are involved, do they have any involvement in Peabody? Does their executive team have any involvement in Peabody? What is their relationship to Peabody? Next thing you might want to look at is the strength of the applicants of the board of directors, the management team, their expertise, the years in the business. Is this their first time? Is this their second time? Once again, just looking at the strength of the Board of Directors. The security plan. You know, we should probably have some type of idea of, do we feel the security plan that they have proposed that night is adequate? That does get into a little bit of a sticky situation. I did have a discussion with the chief of police, understanding that some of the stuff is proprietary, and obviously, we don't want them to come in and, you know, do all the nuts and bolts, because obviously, for reasons that don't need to be stated, that are understood. But I think an idea of the security team, who's involved, you know, any suggestions? We haven't opened up a medical marijuana facility. I don't think any one of us have. They have. Let's take their experience and their strengths, and let's let them share them with us. Let them share what they feel is a good plan and why. I think one of the most common ones is location. We all know that they're in basically the same vicinity, but maybe they feel that they have a better location, a better parking, whatever it may be, a better facility that they're going to design, 2 floors, 1 floor. But I think these are general terms that we can then kind of narrow down a little bit in our own minds to come up with some type of a, once I've always said, a report card. So those are the things that I've thought about. I will be going, and I hope everyone will, you know, I'll reach out to North Reading and try and get that host agreement and get that into everybody's hands if it's a public document. Anything that we can do. So we're challenged here with something that, you know, unfortunately, there's not a set of criteria. We have to come up with some kind of set of criteria that we feel is going to be in best interest of both the citizens and protect the citizens of the city of Peabody. I hope some of my comments have made a little bit of, add a little bit of light to the situation, and I'll turn it over now to Council Gould. Council Walsh, excuse me.
Thank you, Mr. President. I appreciate your comments, and I think especially when it comes to criteria, I appreciate the route you're trying to take. But what I'm concerned about is it seems 180 degrees from what our city solicitor has suggested. So I just want to make sure that I think some of those things can be separated. I think some of the steps you talked about parking and things where one applicant may be more attractive than another, that might come at the special permit process point, not necessarily at the letter of non-opposition. So I'm a little bit concerned about that. I understand, you being the ward councilor, you're concerned about how many would be located in that area. But we zoned a very specific parcel. And even, as you recall, there was an issue with the southern portion of that we came back and changed so that we really condensed the area that was available to any applicant. And we don't know in the end what the applicant's qualities will be. Your suggestions are good. I agree with Councilor Gravel and you that there should be some type of outline, some questions that we should ask, whether it should be specific enough that if we leave something off, we might be in trouble. Maybe it should be more of an informal thing that we do when we have any special permit. We all look and we say, these are the questions we want, and maybe we should be going that route. I'm just a little bit concerned that we would be premature if we said tonight. I think that's a dangerous thing, personally, for this committee to be doing, is saying, okay, we only want one. That might be what we end up doing down the road, but I think at this point we need to be hearing from everybody and deciding all criteria and then figuring out, are they worthy enough to go forward to the Department of Public Health? Have they met that first hurdle? And then get more specific when someone comes back for the special permit. The other question I have is on the host agreement. Are we negotiating that host agreement, or is the mayor? Who is signing off on that? How is that all working?
It would be the mayor, but we would have an opportunity to see any host agreement that was agreed upon before we would grant the special permit.
Okay, so the host agreement would be agreed upon, what, in principle with the mayor's office? prior to their coming here for the hearing for their special permit. Is that correct?
I think that's a fair statement. Would you care to comment on that?
It's going to have to be a collaboration with the council, being informed as to the optimum terms and conditions of a host agreement that the applicant's willing to abide by, so that it's available and on the table for you in deciding the special permit.
Okay, thank you. Thanks, Mr. President.
And I appreciate your comments. I just want to go back to one point that I think is critical that everyone understand, is I understand that you're saying if we give out multiple letters, go to the state, and then let them come back. But we've lost control, Counselor, because what happens is the city solicitor answered, and my earlier question is, whoever shows up at his door with the application, if they come back, Counselor, and we gave them the letter of non-opposition, and they got the certificate from the state, they're pretty well, the assumption is that for us to deny a special permit, I think would be extremely difficult. So once again, my concern is that we're losing control, as opposed to if we give out one letter of non-opposition, if they go to the state and they don't come back, we find that out, we give another one out. But if they come, the assumption is whoever goes to the state is going to probably come back. So now, are we going to be back in let's say there's 3 of them. I would highly doubt, from the research I've done, that the state's going to give them all the certificates on the same date. And they're all going to come back, date A, all the same. They're going to come back at different times. And you know what? I believe that the 11 people in this room can make that decision. And I believe, as you alluded to the fact before, maybe report card is not the best situation because we might leave something out. But I believe after hearing a presentation and doing our homework that I know my intuition, I'm comfortable with that. After the research and the homework I've done, as I said, I'm very concerned about leaving it open to another body that we have no control with, and then we've taken some of it out of Peabody's hands. I'd rather see the people, the city council, make that decision rather than basically how soon the state can turn around an application and get it back to the applicant, who then can get it to the city clerk's office to be time-stamped. I just don't want to be in that situation again. I'm trying to avoid that, and I hope you can be appreciative of that. Council Turco and then Council Gravel.
Thank you, Mr. President. I think we agree and we disagree. I also only want to see one facility on that parcel in that zoning district. Whether we could do that, I don't know. But Attorney Smozinski has advised us that, much to Councilor Walsh's opinion, that that's not the right thing to do. So I don't see how we can go against our city solicitor's opinion I'm not sure how we can go against our city solicitor's opinion of being very liberal with the letters of non-opposition and narrow it down to one. And I do share the same concerns you have with the first one back to the council, gets it, and we've never heard the further applicants. But, this is why he gets paid a lot of money, is to advise us. And he's advised us to be liberal with the letters and to decide. We're going to get sued either way. That's my opinion. We get sued for everything. So I think at this point, I would follow his advice, take this to the special permit hearings, hear everybody's presentations, and if we need to deny and go to court because we denied, then we will. But just my opinion. Thank you.
Council Gravel.
Yeah, I am. I concur with Councilor Walsh. First of all, and please don't take this wrong, but to be dictated to by the ward council that he decided it's one without any deliberation, to me is, I understand you call it your ward, but you're a representative of that ward, and not the owner. And I think every counselor has a right, from a zoning perspective, to have a determination as to what they think should go into a zone. Now, if we want to restrict it to one, then I think we ought to go back to the zoning ordinance and come up with the right restrictions that allow that to happen without putting ourselves in what I would consider to be double jeopardy, because, and you know, maybe had we done this with the billboards, we might have had a better experience, because I was there when we rushed through that. But maybe we go back to the source document if we want to have a restriction, because the double jeopardy to me would be this. 3 people come in with letters, and you say you're only given 1. Well, why didn't you give me 1? 4 parcel owners get to compete for 1 letter recipient. And the person who has the parcel in the zone without any restriction in the zone whatsoever, who says, well, you know, I'm 550 feet away from that place, and I could have the same type of thing, and you're devaluing my property. I think we could get sued on 2 sides. So to me, if we really want to start with a restriction, we should go back to the zoning ordinance, open it back up, and put the restrictions in, just like we would with, for instance, no alcohol within certain numbers of feet of a school. And perhaps, particularly, I mean, we're talking about a small zone, so I get what you're saying, and I understand and agree in principle with some of it, but let's say that zone was 4 miles long. If it was, making the same type of determination would be very difficult. So I just don't feel comfortable saying, you know, it's 1, that's it, we're going to take 1 letter, that's it, and then, you know, we're going to get sued anyway, so what the heck, we might as well get sued from landowners as well as, you know, people who are applying for licenses. If we really, as a council, after we debate it, decide that we should only have 1 available, and any time we put a zone that says marijuana dispensaries are available in those zones, forget about where they are in the city, regardless, if we say there can only be 1 per zone, then that's what we should put in and codify.
I'm in total agreement with you, Council Gravel. Absolutely 100% agreement with you on that statement. It was interesting because at the beginning when you said 1, I didn't know if we're talking about 1 letter or 1 entity, but now as you elaborated, but as I said, I'm totally in agreement with that. And so now I'm going to put the city solicitor on the hot seat and say, if that's the will of the council, how will we go about procedurally doing that? And I don't know if it's the will of the council, but if we want that discussion to take place, how do you advise us to do that?
It's a zoning amendment, just like all others.
Council Turco.
Thank you, Mr. President. Mike, on that note, if we do put 1 in the zoning, are we back to square 1 with spot zoning? You know, have we created another problem?
I'd rather address that in executive session.
Thank you.
Any other council have any comments, questions? I think at this point we had a good start. We vetted some issues, some things bubbled up that have given us reason to think going forward. I'd like to close this hearing of the ad hoc committee, and we will schedule another meeting at a later date. Can I have a motion?
Motion to adjourn.
All in favor, any opposed, to vote? So move.